a market that a consumer is not aware of that data, and what rights do consumers have? And whether it is the issue that we're seeing with social media, whether it is the issue that we're seeing with biometric data, as evidenced perhaps in the state of Vermont's lawsuit against a facial recognition company, whether it is the issue of data brokers and the consumer's right to know. This issue of privacy is a issue not only of consumer protection, but I would argue also an issue of protecting the most vulnerable, and in this instance, kids. I think we all were aware of the congressional hearing that occurred this morning in Washington regarding the algorithms that some companies allegedly were using. Algorithms that, of course, would drive traffic to the site because that is how this business model works. But those algorithms also carried tremendously negative impacts on children. What steps can we take as a state to make sure that we're protecting our kids, that they understand what it means to be online, that not only children, but consumers, adults understand what their data means to them and whether or not they have the right to know, not to opt out, but perhaps to opt in to some of these programs. We know that California, Washington, and most recently the state of Virginia has passed privacy legislation. We know that Vermont will take it up this coming session. And so I look forward to working with all of you. I would say that I think, Charity, you can correct me if I'm wrong, but that data broker bill that I think has been pretty successful. I think we're the first in the nation that passed it, maybe in 18, if I'm not dating myself too much. That's not even controversial anymore. And I don't think it was controversial at the time. But that came out of these conversations. And my hope is that we can continue to have that conversation and look for areas of agreement, look for areas of consensus. I certainly understand that when you talk about businesses, particularly small businesses in Vermont, of course they need an online presence. Of course we understand that in this information age, in a digital economy, we want Vermont companies to compete, not just in Vermont, not just in the United States, but globally. And we understand that they have to be involved in that online world. And that requires and means that collection and that transactional business of buying and selling data oftentimes. But let me be clear, I think we can have a robust economic development plan in this state in this online space while protecting consumer rights. I don't think it's an either or. I think it can be both. We want Vermont businesses to be successful. We want Vermonters to be engaged in a global economy. We want Vermont to be known as one of the best places to do business while at the same time protecting those consumer rights. So, a question that I often pose is this: has technology outpaced the law? And I think, Chris Rice, before you jump in and answer that question, we can say yes, it has. But here's the follow-up to that question. Does it make sense for us to try to go back every single year and change the law in order to keep pace? Or can we go big and make sure that we inject the regulatory framework, that regulatory sandbox, with those fundamental foundational principles of consumer protection? So as a state, we are nimble, we are flexible to the changing economy around us, but also demonstrating that fidelity to the core principles of consumer protection. We can have a strong economy. We can allow Vermont businesses to compete in a global economy. We can attract and retain companies to come to Vermont while also protecting consumers. I don't think privacy is anti-business, and I don't think pro-business means that you're anti-privacy. So my hope is this: let's have a conversation, sometimes a hard conversation where people are going to disagree, but let's find that compromise and that middle ground that satisfies those twin imperatives of economic development and protecting people's privacy. We can do it. We can do it. I think we're seeing it, frankly, in Europe with the GDPR. I think Virginia struck the balance. Let's do it here in Vermont. This is not an either-or proposition. This is all of us working together, understanding that we're in a new economy, but still demonstrating our fidelity to those consumer protection principles in this new economy. So I want to thank you all for joining us. We look forward to the conversation. We look forward to working with all of you. Our office is always willing to listen. We're always willing to meet. If there is follow-up concerns or questions that you have about the process or about this topic in general, you can reach out to us and we will listen to you. We may not always agree, but we're always willing to listen. And I think as we chart this new course, that is what's needed. That is what's critical to come to good policy, is the willingness to listen, to understand from all sides as we navigate this new course. I think it's a wonderful opportunity for our state. I think it's a great opportunity for Vermont to demonstrate that it's going to compete in a global economy while at the same time remaining true to the foundational principle of this state, which is privacy. So thank you all for having me, and I'll report back about how the flag football game goes.
Best of luck, Coach.
All right. Bye-bye.
Bye. So that was a great way to start us off, but why don't I just take a moment and reflect on where we've been. I tried to frame this in the invitation that you folks received. And by the way, just shout out if I'm too quiet, if you can't hear me. It's kind of awkward having the mask on. Ryan.
We hear you fine, no problem.
Thank you very much. Ryan deserves an award for setting up the AV equipment, because we're in a conference room in Burlington where our office is not, and therefore we had to do all this ourselves. So I'm very impressed. So right before the pandemic, Ryan and I were frequently found in the House Commerce Committee advocating that Vermont consider looking at a BIPA. And we gathered together, as TJ mentioned, and we all talked about it, if you remember. And I think the pandemic was in Europe, but it hadn't really gotten to us yet. And there's a video of that innocent time of us on Orca. We were there, we weren't wearing masks, we weren't even thinking about wearing masks. And what we heard was that we needed to do this, that we needed to all sit down and have a few conversations. And so Ryan and I reported back to the legislature that was our plan. And sometime around June, maybe Ryan and I talked and we thought, you know, maybe we should wait a little bit and not do it this fall. And we called the chairs of House Commerce and Senate Economic Development, and they concurred. And so here we are, and yet only Zach and Bridget actually showed up in person. So extra gold stars for Zach and Bridget, and you're all remote. You're cozy at your houses. But I'm glad that we could all be here nonetheless to pick up where we left off. No worries. Oh, and someone needs to be admitted, so I'm gonna hop up.
That's why.
Oh, so you look. See, again, Ryan with the AV, and always good for technology. So as I outlined in the invitation, the idea for these conversations would be to talk about BIPA and also to talk about the CCPA, and we have a third kind of catch-all category of topics that other folks think we need to discuss, and you know, TJ talked more broadly about the issue of privacy. So we're certainly open to conversations that go beyond BIPA and the CCPA, but feel those are two topics that we certainly should make sure we discuss. There are going to be 3 of these. This is just the first one, and we envision that these conversations will go much as they did, and I want to say it was 2018 that we had 3 privacy forums and we talked about various issues. Each one was a little different depending on who was there and who contributed and where the conversation took us, and that will probably be the case this fall as well. To start us off, I asked Ryan if he would just sort of set the table, if you will, to talk about what is BIPA, what is Ccpa, so we can kind of orient and touch base on what those 2 things are. Then I would open up the conversation, but I want us to go around and just introduce ourselves. It's kind of an awkward setup because I'm so far away. I think I can do this, Ryan? I think it would fit. Let me try.
The camera?
This whole computer, do you think it's too far away?
Just needs to be connected to the thing.
Well, I'm gonna try it because I can't see who's talking here. Fingers crossed this works. And then if someone comes in late, I can let them in. Okay, that's much better. You guys can't really see me, but.
I'll try to adjust the camera.
I'm just gonna say it. Ryan dropped the camera. So
It looks the same. Don't worry about it.
can't quite figure out. He's really doing yeoman's work here.
They did not give us the software to control it.
It's true. So he's old.
Now it's at an angle.
I know.
He's using a crumpled up piece of paper to manage the camera.
We have like stadium beach chairs.
Thank you. Some kind person just offered us when we're taking the chairs. So I wanted to go around and have us introduce ourselves. I know I briefly said who we were, and Ryan's gonna set up the camera, and then I'm gonna ask him to show Zach and Bridget. But let's just go around so we know who's here. I'm Charity Clark. I'm the Chief of Staff for the Attorney General's Office, and I oversee our legislative efforts, which is one of the big reasons why I'm here. I'm also an attorney, and before I was Chief of Staff, I was an attorney in our consumer division, and so I know a lot about consumer law. Ryan, would you like to introduce yourself, but you're not on camera?
That's okay. I'm Ryan Krieger. I'm an Assistant Attorney General in the Public Protection Division, where I focus on consumer protection and antitrust enforcement. And I tend to find myself doing a lot of data security and privacy law issues. And I also teach about those issues at the University of Vermont.
Bridget, would you like to
Bridget
join?
more government affairs, and here on behalf of a number of clients, some may come in person at the next meeting.
Did you guys hear that on the remote? You couldn't hear Bridget?
Not very well.
Sorry, okay. Bridget Morris, government affairs.
Bridget Morris is Morris Government Affairs. Zach, you're so far away.
Zach Tominelli with BPER, Vermont Public Interest Research Group. I'll try to project when I talk.
Excellent. So I think what would be most efficient is for me to call on folks who I see, except not sure I really see everybody, but I'm going to try to do that. I think that's best. Jamie, why don't I start with you?
Hey, Charity, thanks. Jamie Fian, Government Relations Director with Primer, Piper, Eggleston, and Kramer. Like Bridget, a number of clients that have interest in privacy matters, including the Consumer Data Industry Association, the American Property Casualty Insurance Association, State Farm, a number of other local and national property casualty and other insurers, to name a few.
Thanks, Jamie. Chris Rice?
Thanks, Charity. Chris Rice, I'm an attorney here in Montpelier, partner at MMR. A number of our clients, similar to Jamie and others, have a deep interest in the privacy conversations.
Good to see you, Chris. Dylan?
Yeah, thanks, Charity. Dylan Zwicky with Leonine Public Affairs, and similar to both Jamie and Chris, we have a number of clients who are interested in this discussion.
Thanks, Dylan. Maggie?
Hi, thanks Charity and Ryan for hosting. Maggie Lenz, Leonine Public Affairs. Same as Dylan and the previous commenters, we have a lot of clients that care about this issue deeply.
So now I'm going to go to the people with no cameras and hope that I can't quite see all of your names. So bear with me, but I believe that's Andy Kingman.
Yep, Andy Kingman with TikTok. We are a scrappy little startup. Some of you may be hearing from us soon.
Oh, nice. Thanks, Andy. Aaron Segrist.
Erin Segrist with Vermont Retail and Grocers Association. Thanks for hosting, Charity.
I think you mean Charity contestant in the Best Bagger competition, 1992.
Yes, that's correct. Thank you for the correction.
Yeah, there you go. I am a really good bagger, just for the record. Jim Halpert.
Hi, I'm Jim Halpert. I am the past chair of the privacy and cybersecurity practice at DLA Piper. I'm sorry I can only join for the first 40 minutes today, but look forward to participating further. I represent the State Privacy and Security Coalition, which includes 30 companies across many different sectors, and have helped to amend at least many of the state laws, including your very good data broker transparency law.
Thanks for being here, Jim. Jim Dandanu.
Yes, hi, Jim Dandino. I'm an associate with Primer Piper, and I'm here, like Jamie, representing a number of clients and monitoring the proceedings.
Glad you're here. Maureen Mahoney.
Hi, my name's Maureen Mahoney. I am a policy analyst at Consumer Reports, and we advocate for strong privacy protections on behalf of consumers in states across the country and on the federal level. Thanks.
Great. Sarah Lashford O's.
Hi, I'm Sarah O's with the Consumer Data Industry Association. We are the trade association that represents the credit bureaus and background screening companies. So thank you very much. We worked with you guys during the data broker bill and look forward to working with you and continuing in the future. Thank you.
Great. Susan Beatty.
Hi, Susan Beatty. I'm the legal contract manager for Springer Miller Systems and a variety of its sister companies. Our software products and services have been affected by GDPR, CCPA, HIPAA, etc. So I'm just here to learn more and provide some input.
Great. Anton Van Sventer.
Hi, I'm Anton. I'm an associate at DLA Piper, and like Jim, I am here on behalf of the State Privacy and Security Coalition, and we look forward to working on this bill.
Great. Chris Delia.
Yes, Chris Delia, Vermont Bankers Association. Thanks for hosting the meeting.
Glad you're here. And Wayne Weichel.
Great, thanks. I'm with the Alliance for Automotive Innovation. We represent the automakers and suppliers that manufacture nearly 99% of all new cars sold in the US each year. Thanks for having me.
Glad you're here. Gabrielle, I see you.
Hi.
Ourselves.
Okay, can you hear me? I don't
Yeah,
see
we
my.
can hear you fine.
Oh, okay, great.
Too. Yep.
Well, hi, thanks so much. I'm glad to be here. I am listening to this meeting on behalf of Apple.
Great. If there's anyone else who hasn't had a chance to introduce themselves, could you unmute yourself and introduce you now? Or did I get everybody?
Oh, hi, it's Tammy Coda, Internet Coalition. Thanks for inviting me.
Thanks for being here, Tammy. Anyone else? So I'm going to transition now that we've introduced ourselves. I forgot to mention one important thing, which is that Brian and I intend to make a report of sorts to the legislature at the end of these forums that we're having. So sometime in December, we'll just send up, here's what we heard, here's what we think, kind of a report, hopefully not too long. But I wanted you all to know that we do have kind of a product in mind at the end of this that we're going to be delivering to the chairs of Commerce and Economic Development. So with that, I think I will just turn it over to Ryan to sort of briefly, like I said, set the table, and then we can open it up for various folks who might have comments or feedback. And let me know if you can't hear Ryan.
I'm going to speak from a disembodied voice here. I have the camera perfectly in frame on Charity, very precariously balanced on a piece of paper, and I'm loath to move it. So as the Attorney General said, our goal here is to fulfill our mission of protecting consumers in this new age of privacy and rapidly moving technology. And although Vermont has no qualm with trying new things, as I'm sure a lot of you know, we think that it does make sense to see what's already out there and not reinvent the wheel if we can borrow a successful statute somewhere else. And I know that that will also encourage standards across the country and predictability, and I know that a lot of businesses value that very highly. So two of the more successful laws that we've seen are BIPA and CCPA. I'm going to start with BIPA because it's easier. This is an Illinois state law, the Biometric Information Privacy Act. I believe it's been around for about 12 years, maybe a little longer. And it's a fairly simple law. It says that if a company intends to collect or disclose personal biometric identifiers, they must obtain consent from the individuals that they're collecting them from. They have to destroy the biometric identifiers in a timely manner. They have to store them securely, and they have to post their retention schedule. I think the reason why most people are aware of this particular law is because it happens to have a private right of action and set liquidated damages of $1,000 per violation for negligence and $5,000 for intentional or reckless violations. And that's BIPA. A couple other states have adopted, Washington and Texas, I believe, variants of this. Neither of them, I believe, has that private right of action with the liquidated damages. Then we have CCPA, and honestly, I imagine most of the people on this call have already studied CCPA. The big thing is it requires consent to gather data from minors, or to share data of minors, I should say. And it requires businesses to put this "do not sell my personal information" link on their homepage. And you can click on that link and ask businesses not to sell your personal information if you're a Californian. And you are a business that is covered by the law, gross annual revenues in excess of $25 million, or if you buy or sell the personal information of 50,000 or more consumers or households, or if you earn more than half of your annual revenue from selling consumers' personal information. You have a right to access information that is stored about you. You have a right to request downloads and which third parties it is being shared with. Those are the highlights of the law. And I am also going to attach a file in the chat if I'm able to do that. I pulled a chart off of the IAPP, the International Association of Privacy Professionals, which side by side compares the Virginia law, the California law, and the Colorado law, so we can see them across. It's very long, and we're not going to go into it on this call, but just as a resource. So that's kind of, but importantly, we are thinking about CCPA, we are thinking about BIPA, or we're open to doing something that is more fitting towards Vermont. And we're seeing how things are developing. These are very new laws, so it's kind of hard to say if they're working or not at this stage.
Thanks, Brian. So that's kind of what is banging around our heads. And I know that from the past privacy forums that we had, sometimes people had a statement they wanted to read, which is fine, or you could email that to me. Where that's, we like communication, so any way you want to communicate is great. But I would love to just start the conversation if someone has something to say on either one of these statutes or just generally. Feel free to weigh in now.
Anyone?
If not, it'll be a very short meeting.
Yeah. Brian and I can go have coffee on Church Street. Bridget and Zach who showed up in person.
Well, if no one else will, this is Jim Halpert, and I've helped dozens of clients comply, or in the case of BIPA, avoid, because it's so difficult to comply with, both of these laws. Really, the answer, I was on a call today with a client that wants to use a facial recognition feature to activate their app. And my answer was, this is such a litigation minefield that you should figure out how to avoid collecting any Illinois citizens' personal data, because it's not just consent, it's a very particular sort of consent. It has to be distinct and separate. It's very, very clunky. There have been more than 900 lawsuits filed using, class action lawsuits filed using this law just in the period between 2014 and 2021 when COVID hit. It was sort of a sleeper, and then the definition of biometrics is so broad that it activated all sorts of different types of functions. Most of the lawsuits have been brought against medium to small employers that use a fingerprint in lieu of a punch card to punch in when you go to work. And the litigation is pretty staggering in terms of volume. What it means is that biometrics is very, very useful for fraud prevention. And fraud prevention companies, though, don't mess with it and just don't deploy their services in Illinois because of the litigation risk, because it's so difficult. You can't tell a fraudster, get them to consent to using this technology. And the plaintiff's lawyers have made millions and millions of dollars in lawsuits and are just sort of hovering, waiting for targets to sue. So I'd submit that this is not one of the most successful laws. Its balance is just a little too far on the plaintiff's bar and sort of gotcha side of the ledger. I don't know. I mean, I think that the Texas law doesn't have class action enforcement. It has not been rigorously enforced, but it has basically the same requirements. I think the happy medium there is something more like Washington State, maybe a little bit more than that, but that's probably something that would better serve Vermonters' interests. I think biometrics information should not be able to be bought and sold, and the sort of scraping that Clearview did should be totally actionable. But that's very, very different than saying that all collection of biometric data, including directly with a service where the consumer intends to activate a feature because they like facial recognition on their device, should be subject to all the requirements of BIPA. With regard to CCPA, and I apologize, I need to jump soon, but this is just a discussion start. All the rights in CCPA make sense. It's a very well-meaning law, but it's very, very poorly drafted and confusing. And I think if you ask Maureen, I think she'll agree that the consumer groups don't love it either. But you could certainly do something that conveys all these rights and more. There are more rights in Virginia, for example, or Colorado, in a way that's much shorter and clearer and more easily understood by businesses. I'd also say that the threshold to be covered by the CCPA is actually very, very low. The definition of sell is actually a misnomer. It really is any sort of monetization of data. It's very confusing, and consumer groups are not crazy about that. But literally, if you have advertising trackers on your website and 50,000 unique visitors visit it a year, which is about less than 10,000 a month, you're subject to the CCPA. So if you actually want to help Vermont businesses to become competitive, you do not want to use CCPA as a model, and you certainly want to have a much higher threshold of what would be covered by this. CCPA has been the subject of no less than, I think, 9 different proposals. It's been amended twice. There have been 7 or 6 proposed rules, kept adjusting it. And now there's a CPRA initiative that was passed because there was unhappiness with the CCPA. That's going to spawn a whole bunch of other rulemakings. And, we're talking probably 2023, 24 before the dust settles there. I'd submit that Virginia or, some with maybe adding a couple things from Colorado is probably, if you wanted to do something that was less burdensome and you also had a bigger threshold for coverage, that's probably a better place. You would have more rights for consumers than exist under CCPA. Consumers and businesses alike would be more likely to understand it. There would be more compliance. And frankly, your job as the AG's office of protecting consumers would be a little bit easier because you wouldn't have this hairy, confusing mess as the item that you needed to enforce. To give you an idea, the latest version of the CPRA, including strike-throughs of its changes to CCPA, is 55 pages, and it is staggeringly complex. I just spent about 4 hours redoing vendor clauses that a client had to protect personal data to comply with CPRA. Now, this becomes a form, but I could probably delete the name of the name and the name of the client and send you over to it. And you could see the intricacies simply of an agreement between 2 businesses where one of the businesses is going to act as a pure service provider. These are the sorts of costs that are great for lawyers like me who can charge $1,230 per hour for my work. It's great for my business, and my business has more than increased by more than 40% since CCPA went into effect. But I don't think it's overall ideal for consumers. It sort of elevates form and obscure drafting that's hard to understand over substance. And I think if you guys look at it from that perspective, I don't think it's a very successful law. There's widespread non-compliance with it. And you could do something that was simpler, clearer, and frankly more appropriate for a state like Vermont and give consumers, maybe it'd be a little bit lighter in terms of the scope of the definitions, but it would have way more rights. And I think it would be a major, major win for consumers. So I just wanted to leave that with you guys. I need to jump in a few minutes, but since no one addressed these questions, I wanted to talk since I really do have a lot of experience working with these statutes, and I don't think either one is a good start, but I think there are much better models out there to work from. Thank you.
Really appreciate that, Jim, and you're singing a song I've certainly heard before. So really appreciate that perspective. I wonder, Maureen, if you want to respond.
Sure.
You on the spot. If you want to pass, that's fine too. But just
Maureen and I are doing a conference at IAPP together, a panel, which I'm really looking forward to. Please go ahead, Maureen.
Thanks. I do agree that in many ways the CCPA is very complicated. A simpler model would be good. And it isn't necessarily legislation that made anybody really happy because it was inherently compromised legislation. But I do appreciate that the states have begun to make these efforts to establish baseline protections for consumers, particularly in light of the lack of federal action. But, Jim and I do differ in that we'd like to see legislation that's actually a lot stronger than the CCPA, particularly with respect to the opt-out model. At Consumer Reports, we had about 500 consumers test the CCPA by submitting opt-out requests at companies that are on the California Data Broker Registry. We found that about 14% of the time, the opt-out procedures were so complicated that it effectively prevented consumers from stopping the sale of their information. So opting out at one place can be difficult. opting out at hundreds, if not thousands of different companies can be even more difficult. So we'd prefer a stronger model based on data minimization that limits what companies can collect, use, and share in the first place so that consumers don't have to worry about opting in or opting out. If it is an opt-out model, at the very least, it needs to be scalable and workable for consumers. For example, companies, as in Colorado, should be required to honor opt-out requests submitted through browser privacy signals so that in a single step, consumers can opt out of the sale of their information at every company with which their browser interacts. So that's something that Virginia, for example, does not have. And that's a way that it could be stronger and more workable for consumers. There also need to be controls over targeted advertising. Data shared to other companies in order to deliver ads should very much be covered by some sort of control. So it's really important for there to be strong definitions that clearly cover that. So we would have some tweaks to the Virginia model to be sure that this information is covered. And then we also think that strong enforcement is really important to incentivize compliance. We've been strong opponents of so-called right to cure provisions that say that if a company cures a violation within 30 days, that they can't be penalized. For many of these violations, there's no getting the horse back in the barn after a consumer's data has been inappropriately shared. We'd also like to see some sort of private right of action to help incentivize compliance, especially in light of lack of resources for attorney generals. So those are some of our key points with respect to CCPA style legislation.
Brian has a follow-up question.
So Maureen, am I hearing that if we were to go with modeling on one of the other states' comprehensive laws, Colorado would be the one to start with as opposed to CCPA or Virginia? Is that the one you think is the most, the best platform to jump off of?
Well, Consumer Reports does have model legislation that we think is the best approach that does use this data minimization approach and has really strong definitions. I think CCPA, as amended by CPRA in terms of existing comprehensive legislation, is probably the strongest. We'd like that to be the floor for any legislation. We've also supported versions of the Washington Privacy Act, for example, that have been amended in the House. I think that's been a bit stronger. So I think the CPRA should be the floor for any state comprehensive privacy legislation.
And the problem with CPRA is that it is so confusing and operationally really difficult. I mean, the CCPA alone had, according to the AG's office's own economic analysis, was going to cost $55 billion for entities to come into compliance aggregate. It's changed a lot. CPRA adds to that, and it's just, if you guys can spend a little time with CPRA and see if you understand it. There are weird categories that overlap of contractors and service providers. And nobody, even the people who helped draft it, understand what that means. So while there are additional elements in it, and it does have I think a data minimization or sort of use limit on sensitive data, which I think is worth thinking about. It's not it doesn't solve all the confusing, and in fact, kind of compounds the confusion in CCPA. So I would say if you guys are looking at adding something else beyond Virginia, it would be good to work, from a clearer framework, and then consider, obviously the business community is going to probably agree with one or two things that we just heard from Maureen, but and disagree strongly with others. But I do not suggest starting with CPRA as the basis. I mean, it's a joke how confusing it is. And if there are ideas, again, from there to transpose someplace else, let's have a debate about those. But I wouldn't pick something that, every business is going to need to pay lawyers, hundreds of hours to help them just understand the thing, much less come into compliance.
Could I throw another question out to the whole group? And this is really just a broad question. The Fair Credit Reporting Act contains a lot of protections in it. Right to amend, right to access, right to find out where your data came from, when an adverse effect comes to it. You could look at that law as kind of a data broker regulation, a data broker focus regulation that just focuses on a very small subset, the credit reporting agencies, and a very small subset of data, the credit reports. But if one were to expand that to just cover a broader type of data and a broader type of business, it seems like all of the protections and all of the issues would kind of be swept in. And it's a law that we have about 50 years of experience with, including case law, including textbook. What's wrong with that idea? I'm curious as to what I'm not seeing in terms of the weaknesses of just expanding. And by the way, Vermont actually has a state level Fair Credit Reporting Act that was grandfathered in to the federal Fair Credit Reporting Act in some parts. Now there may be preemption issues, but putting those aside, what are the issues with that?
Responses?
That's also a radioactive, client after client, when they come to us and say, we're trying to do X or Y model, it's so difficult and complicated. Credit bureaus are great at complying with it, but it also acts as a barrier to entry because it's so complex and hard to understand, and there is massive class action risk there as well.
Anyone else have any thoughts on that or any other topics?
CDIA, anything?
Hi, this is Sarah O's. I apologize. I'm in a car, so I hope you can hear me. Obviously,
Sarah, you're breaking up a little bit. Can you hear us? Sarah?
Yeah. Yes.
Sarah,
Now we
you
hear you.
broke up a little bit. I wonder if you're in kind of a bad spot for cell service.
Oh, can you hear me right now?
Sort of. Do you want to try again? Sarah, I think we'll come back to you. I'm wondering if you're in a bad spot.
Oh, sorry. Are you able to hear me now? I apologize.
You keep going in and out.
Let's see. How about now? Can you hear me now? Is that better?
Yes, it is better.
Okay. I was just going to touch on some of the issues with CCPA in terms of highlighting what Jim was pointing out in terms of how confusing and poorly written, I would say, simply because it was written by so many committees and so quickly. When you look, for example, at the Fair Credit Reporting Act exemption in the CCPA, it is terribly confusing, even though it gives all the things that my guys need in order to continue to do their work and giving that exemption, but it's so verbose and written in such a way that is terribly confusing. And while the Virginia Privacy Act gives the same protections that the CCPA does, it's written in a streamlined fashion that is easily understandable. So I'd just like to highlight that when you go back to look at models and just sort of second Jim's point that the CCPA is written in not a great way to start as a base. And I think Virginia learned from CCPA and has streamlined the language and such that it makes a lot more sense. So just wanted to second that.
Thanks, Sarah. Zach Cominelli from BPERG has something, so just let me know if you can't hear him because he's kind of across the room.
So just an immediate response to Ryan's prompt, that is not something that I had actually thought about or considered. So my response right now is actually that I don't have one, but I think I'd like to think about that and further that discussion at one of the future hearings. So that's an interesting point. Just in general response to some of the things that have come up, it would probably not be shocking, largely in agreement with Maureen in terms of what their approach is to something like CCPA or more kind of comprehensive data approach. So second, a lot of comments there. Returning to the concept of BIPA, and I guess let me just take a step back and say, to the extent that the legislature is thinking about this and thinking about what work they want to do, what they want to prioritize, if they're up and willing to do, something more comprehensive, BIPA, we'd be totally on board, recognizing, how the state of Vermont approaches these things often. If you were focusing or prioritizing a particular element, biometric privacy strikes us as a logical place to prioritize or start. And the reason why we worked on all kinds of data privacy issues, so it's not as if non-biometric privacy is not important, but just worth noting why we think it's so critically important is, unlike other pieces of data, biometric pieces of data cannot be changed. It's not like a phone number. It's not like a password, even your name you can change. So if the legislature is looking for prioritization, that would be a reasonable place to start. And might not surprise folks to know we don't exactly share Jim's perspective. We do think that it's a good starting place for a law. There are even ways that we think you can even make it stronger. But in the spirit of kind of consensus, I was glad to hear that practices like what Clearview AI participated in. Some industry folks are saying, yeah, no, that shouldn't be allowed. Yeah, let's start there and make sure that we're protecting Vermonters in that sense. I don't think that we want to necessarily encourage frivolous lawsuits. I think we could debate what is frivolous and what isn't frivolous, and what would be frivolous to some people is what we might think is important protection. So we do think the private right of action is what makes the Illinois law actually the gold standard, actually really worthwhile. So wouldn't want to lose that. But I would just come to say, our position hasn't really changed that much in the last 18 months. The last time we had this conversation, we think BIPA is a good starting place, and we would like to see the state of Vermont take a look at that and potentially pursue that.
Thanks, Zach. Any
I
responses?
just want a quick response, and I apologize that I've got to go pretty soon. No, BIPA was enacted in, I think, 2008. No state since has enacted this framework. It's been now 13 years, and there are pretty good reasons for that. And I think the most fundamental one is it will make Vermonters less secure, because it's different when you take biometric data and you pass it along to other people without service provider protections, that sort of thing. But if you're using biometric data to prevent fraud, that's a good thing, not a bad thing. And if it's different, if the biometric data becomes part of a profile that's then shared and used by lots of other people, or if it's scraped, that's a different sort of issue. And BIPA is a meat-axe approach and just says aim the $1,000 to $5,000 class action at any collection of biometric data. Even if you try not to collect it, in some cases, businesses are going to collect that sort of data. And so I really think that to the extent you guys want to tackle biometric data, there are ways to have strong enforcement. There are ways to have something that gets at bad actors and that prevents biometric data being commercialized heavily. But I really think that this is ultimately an anti-consumer piece of legislation. It's certainly pro-plaintiff's bar, but we're seeing fraudsters who set up and take advantage of the absence of biometric screening in Illinois because they know that there are weaker targets there. And I don't think the AG's office, in its role, protecting against crime, should be advocating a particular solution that is that extreme that it creates that sort of risk.
Jim, I think it would be very helpful to us in the legislature if you could point us to any academic research or things like that of the.
We have some business research. I don't think there's been a systemic study done. I'll try, but I can definitely get you some business research on that.
Thanks, Jim. Other comments?
Has anyone taken a look at the consumer reports model legislation that was just mentioned? This is actually the first I've heard of it, so I'm not saying one way or the other. Have you folks at Berg taken a look at it? Or?
Yeah, I've seen it. Now that it's sort of, I didn't know the consumer reports was even going to be here. I'm so glad they're here. I do think that that is a very good starting point. I'd be interested to, discuss that further, future hearings, pursue that, and, ahead of future things, if that's something to put on the table, I think we'd be willing to take a look and say, these are the aspects that we particularly support, but I would endorse it.
Maureen, would it be possible to drop that in the chat of this Teams call?
I haven't been.
Yes, I will do that.
Oh, Ryan just muttered that he's been struggling to share documents. So if you can't drop it, Maureen, you can email it to me and I can email it to everybody on the call.
Actually, you know what?
I can predict. I have looked at this draft, and I can predict that the businesses on this call are not going to be crazy about features of it. And I'd also suggest that businesses are building compliance programs with Colorado and Virginia. And thanks, Ryan, it's now posted. And that's a major lift for states for businesses that operate in multiple states. And so doing something that's different than that and different than CCPA is going to be a further sort of expense and burden. And I'd suggest, Maureen had suggested amendments to the CCPA, the Virginia law rather. And I'd suggest that would probably, if you want to do something that's going to be less expensive, it would probably be better to look at those ideas on their merits and think about how they fit into the Virginia law, including things like a do not sell signal, or do not track signal, which Colorado is going to issue final rules on in 2023, I think, and by the summer of 2023. And that may be something to look at that point, for example, to address the problem that Maureen raised about the opt-out burden. But in due time, because you can't really have two different signals in different states without having dormant Commerce Clause issues about something like that and First Amendment issues. But there are things happening in Colorado that you guys may be able to take advantage of in due time. I just would urge you not to implement a solution early that will then be different than what happens when Phil Weiser finishes the job he's doing in Colorado. But if you start on the model, the Consumer Reports Model Bill, I think you will find significant business opposition and just a desire to work off something that's generally consistent, and then adding additional ideas or debating those. Thank you.
I will say that this is certainly our ideal legislation, and we understand that there would be pushback, and we're definitely happy to, work with all stakeholders to see if there's language that could be worked out that no one has any objections to. But when we were drafting it, we did try to look at the CCPA and language already out there so that it's not creating something out of whole cloth.
Thanks to you both. Other comments?
Charity, it's Chris Delia. Ryan had mentioned earlier he was going to post the 3-state comparison in the chat. Is he able to do that?
He's clicking away.
Yeah.
Thanks for the reminder.
Yeah, I figured out
how to drop something.
It's just, I'm just posting a link to it, and that's how you do it. So, there you go.
Perfect. Thank you.
Thanks, Chris.
How about the new Uniform Privacy Act? Does anyone have any opinions on that? No, I don't know that anyone has proposed that in Vermont, but I've heard it has been proposed in some other states. Any thoughts? This is from the Uniform, I forget the name of the organization, Uniform Laws Commission.
Law Commission.
Yeah. Anyone have any thoughts on that?
I have some thoughts, but I don't want to completely dominate the discussion. So I'll try to be brief. I think that measure goes way too much on the side of flexibility for companies in trying to reduce compliance costs. It doesn't really provide any substantive protections for consumers. I think, it's generally too vague, and I think a better approach would be, having clear provisions that companies have to comply with, and then having strong enforcement to incentivize companies to comply. So I don't recommend taking that approach.
Anyone else have opinions on that Uniform Act?
Do we know if anybody from Vermont was involved in that development on the Uniform Law Commission?
So I actually believe one of the reporters was actually a Vermonter. I'm blanking on his name. But I mean, I sat in on a lot of those conversations. A lot of my colleagues from the AG community sat in on those conversations. And we had other conversations, conference calls with folks who were drafting it. And I will just say that a lot of the suggestions that we made were not incorporated into the final draft. But we did not, I'd say we did not influence that law.
Diplomatically put.
Well, welcome to dealing with the Uniform Law Commission. I mean, that's pretty consistent with a lot of people who interact with them. So don't feel like you've been singled out.
Pam Dixon had some significant input in that draft, I think.
Okay, here, to take this in another direction, let me ask this question. So a lot of the laws that we've been seeing are basically giving consumers new rights to do X, Y, and Z, to opt out, to get your information collection. Another approach, another very consumer protection-ish approach, is to just clarify what is an unfair act. And that might not be the full answer, but I'm wondering, is there anything, to say X is on an act, a business just shall not do X. Is there anything that there can be general consensus on, that we can all agree on? It's just things businesses shouldn't do. So now we're talking about the scammy businesses, the bad businesses, that, the straight and narrow businesses would never do X, Y, and Z. Is there anything would that be a direction that we could say? And because as we all know, just saying something's unfair or deceptive has a lot of costs to bring it in court. What do people think about that approach? Maybe not as the full approach, but an additional.
No state has done that, but that could be fruitful in some ways. But adding that to the CCPA would not be something I think the business community would want very much. It depends on what's in the rest.
Well, I mean, I guess one thing that some states have done is it is an unfair act to have bad data security, right? Or you shall have reasonable data security. So that would be one that I can think of in that area, and we don't have one of those other than with regard to data brokers. So it would be an unfair act to knowingly sell data to terrorists. I mean, I'm just spitballing, things that we could all kind of get behind, or to identity thieves, right? To knowingly sell data to identity thieves.
But then how do you exhaust the list? Like, it's your imaginations.
Well, I mean, that's why we just call things unfair and we don't try to enumerate things. But there can be certain broad categories that perhaps we could just say, look, we don't want anyone to do it. If it shall be an unfair act to screen scrape a database of 3 billion images and then create a facial recognition app, for example.
Use a random example.
Use a random example.
I think Consumer Reports would be supportive of such an approach. I think Senator Brown did similar legislation that he introduced, I think in 2020, along those lines. I like it that it doesn't put the onus on the consumer, again, to opt in or opt out, because that can be a lot of responsibility. And again, for opt-outs, it can be difficult in terms of scale. But then, coming to agreement on what would be prohibited, the devil would be in the details there.
Mm-hmm.
Yep.
Any other comments?
I would also add to that, who's it going to apply to? Because you know, there's a lot of small businesses that we have in Vermont that also collect data that are considerably more vulnerable than some others out there in the marketplace. So if you set a high threshold because we want to be business friendly, I certainly can understand that, but sometimes those data breaches are happening in smaller businesses, and that can be just as big a problem. So if you're going to go down that road, you got to be mindful of who it's going to apply to.
Do you think that the CCPA limits would not be appropriate for Vermont?
Wait, can I clarify? Do you mean actual CCPA or are you talking about another state model?
No, I mean the actual ones in the CCPA. You know, I'm just wondering, would you know, gross revenues in excess of $25 million, buys or sells info of more than 50,000 consumers, or more than half of annual revenue from consumers personal, that can apply across the board. But would, if we went in a CCPA Virginia, Colorado direction, would thresholds be necessarily need to be lowered? Is that what you're suggesting, or?
Well, let's go back to a natural food store in Vermont that had its system compromised, or pick any other entity in Vermont that has its system compromised. I think we need to figure out what is the appropriate scale for businesses out there to implement security measures. If I'm a small mom and pop and I have one computer and I'm conducting transactions on that computer, and then I allow staff to use that computer for searching the web or responding to email or doing whatever else they may do, that system is certainly vulnerable, and you could scale up for businesses. But if you don't have businesses implementing some level of security, then consumers are going to be vulnerable out there. They'll go after those systems. So I won't respond as to whether they're the right thresholds, but $25 million, who are you really going to capture in Vermont with that type of model? And I'm not trying to be anti small business. I'm just trying to, you know, put some reality to it, that there's a lot of businesses whose systems aren't protected and they could be compromised quite easily.
Yep. Thanks, Chris.
The one thing I want to point out with respect to thresholds, actually a couple of things. So first of all, CPRA amends CCPA, and that raises the threshold to data collected from 100,000 consumers per year. But, you know, that's with respect to California and their very large population. So sometimes you'll have these same thresholds in bills introduced in other states with a much smaller population. So that would end up being a much higher threshold. But I don't know if we've identified a magic number in terms of a threshold, other than that we don't have a problem with the 50,000 number in CCPA and the 100,000 number in California tied to the population of that state.
What else do we have? What other comments, questions, or do people want to change the topic and talk about something other than BIPA or the CCPA?
Can you refresh my memory, because we've been in this virtual legislative world for the past couple of sessions? Wasn't there a bill dealing with minors and protection of minors that got introduced in the legislature?
Are you talking about the old biennium or last year?
It could be the old, it could be the 2019, it could be 2020. I just, for some reason, I thought There was a bill that got introduced dealing with minors, and did that not go anywhere? Because I was listening to TJ in his opening remarks talking about minors, and I thought there was a bill that was concerned about education access or something like that.
Yeah, I remember that one too. I think that was in the before times. And I can't remember. Does anyone else on the call, before I just start, plumbing the depths of my brain, does anyone else on the call remember what happened with that?
You're part of the student privacy legislation that got enacted.
Right.
I don't know if that's something that, but.
And Philip Baruth was like worried about one portion, and so they had to.
Yeah, and it got wrapped into other consumer protection. There's
Yeah.
a bill that actually dealt with several kind of disparate things.
Right.
But included in one of them was student privacy legislation that essentially prohibited entities from selling data that was collected by students or using it for other purposes other than education.
It's like FERPA plus. Okay. Did you hear Zach, Chris?
Yep.
Okay.
Yep, that's helpful. Thank you.
Let me ask another question to the group. And I want to preface this by saying, if anyone's trying to read tea leaves, this is not trying to imply that our office is going in any way. We're really just trying to have a discussion and understand different ideas, this kind of brainstorming thing. When the data broker registration was passed, it was intentionally very light touch legislation. Does anyone think that there should be any aspects of that law that should be updated now that we have sat with it for a few years? And if so, what might that look like?
Anyone care to weigh in?
This is Sarah O's with CDIA. I think I would like to see the data broker, the definition of a data broker expanded so that you don't just regulate a small subset of the data broker community, but rather you focus on the larger data broker world.
So do you mean first-party data brokers? Or
I'm sorry?
Yeah, I'm really interested to hear, because we did spend a lot of time on that definition, which parts of the data broker world you think are being left out by that definition?
I think there's a very small set of the way the definition of data broker is defined, and it doesn't capture the largest data aggregators nationally that are exempted out of that. And so I think if the bill really wants to be strong and purport to truly regulate data brokers and have a light touch, but have the regulation where data brokers are registered, I think that it's almost a disservice to Vermonters that there's only a subset based on how narrow that definition became in the end, and instead that it encompasses the larger data broker community.
So when you say that there are large aggregators that are not included, would you mean businesses that are collecting data directly, that have a direct relationship with the people that they're collecting data from? Is that what you're talking about has been left out?
I believe so, yes, and others.
Thanks, Sarah. Any other comments?
I mean, we'd like to see more comprehensive privacy legislation that puts limits on, collection, use, sharing, access, deletion, things like that. But, if, you wanted to do a more modest improvement, giving consumers the right to, in one step, opt out of the sharing of all of their information by data brokers through this data broker registry. I think that would be an incremental step that could be helpful.
And what would, are you talking kind of like a do not track list, kind of like the FTC's do not call list, or how would that look?
Yeah, we've advocated for something similar to that, kind of a do not call, but for do not sell. Or, I mean, this, wouldn't necessarily be tied to a data broker registry, but, if you did like an opt-out bill, where consumers could opt out of the sale of their information, but they'd be required to honor these global privacy signals. So consumers could opt out of the sharing or sale of their information in one step. It wouldn't be everything we'd wanted, but that would be an incremental improvement.
Anyone else want to weigh in on that, either for or against?
I mean, I'll weigh in for that. Again, that would be incremental, but we like when the data broker bill is being debated, we like the idea of requiring companies to allow folks to opt out. So that hasn't changed. I guess I'd be curious, Ryan. I mean, I think I have a sense of this, but maybe just for kind of purposes of the discussion, from your perspective, you asked about improvements or changes to the data broker bill. We're now a couple of years into it. What has sort of compliance looked like? Just sort of an update on that in terms of what you've seen from your office.
Way to turn the tables. I mean, we have been reliant on academics and journalists and advocates to inform us where someone should have been complying and is not. I think one of our biggest success stories with the data broker law happened in the first year. And what happened was we got a contact from a journalist who informed us that there was a company that was local to that journalist who had posted that they did not sell the information of children. The journalist said they do. You can go on their website, they're selling high school students lists. And we contacted them and said, what's that all about? What's going on? And they said, oh, we had no idea we were selling high school student lists, but we're not going to anymore. Now, mind you, it's not illegal under the law to do so one way or the other. That was an example of just sunlight changing behavior, which I thought was very interesting. It also highlighted the fact that we recognize that there's not actually a penalty in the law for providing incorrect information in the data broker registry. So maybe a bit of an oversight there. So, that was a success. I would say another success involved a company that screen scraped 3 billion photos and put them on the internet, who submitted a broker registration stating that they collected information of children, which was one of the things that drew our attention to that company, in the first place, and made us look deeper. So that was certainly something successful. So, and I think some of the bigger, another area where we could call it a success is the fact that when California passed the Ccpa, they looked to our law and said, if we're going to have do not sell, we need a way for people to have do not sell from data brokers, but no one knows who the data brokers are. So let's, bring this, and I've gotten outreach from a number of stakeholders in other states with ideas about what they want to do about a data broker registration. So that first mover, making the impossible possible sort of role, I think, has been an important part of the.
Thanks for that walk through the past couple years. Anyone else want to weigh in on the data broker registry or BIPA, CCPA, any other ideas banging around? Concerns?
I'm going to throw another question out.
Brian has more questions.
And this is trying to gather some expertise here. One of the issues that we often run into when it comes to opt-out is how do we verify that the person wanting to opt out is in fact that person? And often that requires the business to ask them for more information about themselves to opt themselves out. And so does anyone, I'm sure that you've all thought on this, what is the best practice for, let's say we had an opt-out list and there's a bunch of names on it. So how does a data broker say, well, this is the John Smith we need to delete from our records, but without requiring people to give the data broker their social security number? How would that work in reality? Does anyone have any thoughts on that?
I mean, my initial thoughts are, to point out that the CCPA pointedly does not require identity verification for opt-outs. It does require identity verification for access and deletion requests, because when you're giving someone data or you're deleting someone's data, you really want to make sure it's that person's data. Otherwise, like a roommate could access the data, and that would be bad. But for opt-outs, there's no privacy downside to opting someone else out on their behalf, or opting out of pseudonymous data, which is data that may be tied to a device and inherently associated with more than one person. So the CCPA was written to make it really easy for people to opt out of the sale of their information, for companies to not, require your driver's license in order to opt out, because a lot of consumers don't feel comfortable, showing a driver's license to a data broker. But also, the CCPA allows consumers to opt out of this pseudonymous data, which is data that may not necessarily be associated with one single person, because that's a lot of the data that's implicated in ad tracking. So we're definitely supportive of kind of expansive rights with respect to opting out.
Other thoughts? So I will kind of come back to where we started if no one has more to say at this moment, but just to kind of crystallize the situation, before the pandemic, Ryan and I sat in House of Commerce and said the Attorney General's office thinks that this committee should look at the Illinois BIPA. That is what we are advocating for. That is our recommendation. That's what we think you should do. And I think it was the chair who said, well, why don't you get together with stakeholders? So that's what we're doing. So I want to encourage anyone who has thoughts or comments about Illinois' BIPA, which is where we recommended we began, to speak up and let us know, because that's what we're looking at. That's where we started, was to advocate that the legislature take up a bill that looks like BIPA. So I want to emphasize that's where we're coming from and where we're headed with your input and thoughts on the matter. Any takers?
So certainly we'll take a look at it, since that's the direction that you want to go in. So under that bill, what's your thought on the iPhone that uses facial recognition to open up the phone or open up an application on the iPhone that you would then use for My Community online banking? Same thing would be true for your computer. What's your thoughts on surveillance cameras that are used in businesses, many businesses throughout Vermont, but in my business, to capture anybody who is acting inappropriately within that business, bank robbery, somebody driving up to an ATM that's sitting in front of a camera? What's your views on that type of technology? Because we're not going to be able to notify them ahead of time before they drive up to the ATM that there's a camera there for their protection. So those would be the types of things that I would be interested in. And I guess I'll go back to the comment, no other state has adopted this law since it's been out there. So there's no other models to consider. There's nothing else that you've looked at that would address your concerns of biometric data?
So I will let Ryan, who's more familiar with the, speak, but I think that it's possible that not everybody uses the tools available to them for their own security, like, the iPhone opening up using facial recognition. And it's possible that people are willing to take the risk of, the way things were 10 years ago or whatever, before that technology existed, because their privacy is more important than their, security with their iPhone or whatever. So I think there's a tension, but I'll let Ryan answer questions more specifically about BIPA.
I mean, I think you raised some very interesting examples. As far as an iPhone goes, I mean, there's clear consent there. You turn on the biometric, right? But with respect to the public surveillance camera, a different thing. I think that from a policy perspective, what BIPA was trying to get at was a company that would collect biometric identifiers for their own long-term use. That would not be the situation of a security camera, even if it's biometric enabled. Now, you get the camera footage and you need to compare it to something. So where do you compare it to? Maybe you get a third-party database where they have gotten the consent. But I think you're right to the extent, and by the way, I posted a link to the actual legislation in the chat. If the law does not distinguish between those different scenarios and creates confusion, then perhaps that's a confusion that we can clarify, assuming the legislators really don't want to, get at the public surveillance camera. Right, I can get consent in that. And, I mean, I know that for my retirement account, they use voice recognition to confirm that I am who I am when I call them up, which is, I think, probably a good thing. They can weed out someone who's trying to impersonate me.
That you chose to activate that.
Well, that's a good question. I don't recall choosing to activate that. But that's my point. That's my point, is that that's another example of fraud prevention that maybe is better, or that maybe there are certain circumstances. Now, to go and say fraud prevention is exempted, that might be just way too broad an exemption, because then everything could potentially be fraud prevention. But you raise a really good point. And this is exactly why we want this kind of forthcoming communication. I'm gonna give you an example from the data broker bill. After the data broker bill passed, I started getting calls from background check companies asking if they had to comply with the data broker law. And I think there are a lot of different models of background check companies. There's probably people on the call who know more about the model than I do. But one company called and said, look, we collect, what happens is, if someone gets a job, the company runs a background check on them with their consent. We pull the data from third parties, compile it into a background report, provide it to the business, hold it for a year as we're required to do, and then delete it. The consent, but we are technically collecting information from third parties. And so are we a data broker or not? And, my response was, wow, technically under the wording of the law, you guys are a data broker, which is unfortunate, because if this exact scenario had been explained to us while we were drafting the law, there are like 3 carve-outs. There are 3 very specific carve-outs in that law from people who came to us and said, we really don't think we should be in here, and here's why. And we said, yeah, that makes sense. And we did it. And, I think that their representative may have actually been in the room when we were drafting. And I said, well, they just said, don't pass the law, but they didn't offer any recommendations. So this is why telling us and being forthcoming, because we really are trying to get it right. We're not just trying to pass something to pass something. So maybe that is something that can be fixed, and if there really is this confusion over what consent means, then maybe we can make it clearer what consent means. I mean, the first draft of any law is always going to be problematic. So that's what we can, do if we go that way.
Less problematic if we all work together and communicate.
Absolutely.
Getting my guitar to sing Kumbaya. So we have more time to talk, but I see that now I can't see any of you. I only see myself. So we don't need to belabor the conversation. We have a lot to think about already and kind of reflect on before our next get together in 3 weeks, I think, 2 weeks. Is there anyone else who wants to weigh in? Chris, I see you. Do you want to weigh in?
No, I just didn't want you to feel lonely,
Oh,
so I threw the
thank
camera
you.
back on.
And Jamie too.
There's
Thanks,
Jamie.
guys. Thanks, Jill.
Well, and
Never
Ryan,
want anybody to feel lonely, right? Exactly.
this
No, Charity,
is
thanks.
Sarah
I mean,
O's,
I kind of look at this as sort of a way to level set and get a refresher in terms of where we are. So having heard the conversation today, I think we'll all be armed, or prepared to be armed with some more concrete comments for your next meeting.
Yep. And I mean, I'm not sure if I linked to it or not. Did anyone know if I linked to the conversation that we had, that Orca had filmed, so they still have the link live. That might be useful. It's funny, I was reflecting like, oh, and then we had the conversation in the committee, and I was like, no, remember, Charity, there's no YouTube channel back then. That was like no one had thought of that yet. It's like, oh, that doesn't exist. That's right. There's no easy way to grab that. But you can always refresh that way too by going back and looking at the Orca video.
well, and this is Sarah O's, and back to Ryan's point, because I represent the background screeners and was very heavily involved in the data broker. I do hope that if you guys do present legislation moving forward on this, that unlike the data broker where we were getting 5 iterations of the bill and in a day as it passed, I hope that there's a little bit more transparency as the final enactment goes into play, because I know that was something that certainly was frustrating on our end as language was changing and things were moving, and we were not getting that information in a timely manner. And I really appreciate the fact you guys are doing listening sessions again, because I think it was beneficial the last go around. I just hope that as things start to finalize, that we continue to have that open dialogue and transparency moving forward.
I think that was actually an example of excessive transparency. We really were creating edits and turning them out very, very quickly, but we were getting them out to the, as soon as they came through.
And hopefully it will be even easier this session if the legislature continues to film stuff on Zoom, and it'll be easier for those who can't physically be in Montpelier too, which can obviously.
Absolutely. Well, thank you again. I really do appreciate this was very helpful today.
Great, good. Thanks, Sarah. Any other comments?
Just a point of clarity on both the broader privacy bill and BIPA. Are you considering that those would apply to state government as well, or would state government not be in the mix?
I mean, at this point, we're hearing feedback. So I can't say we're considering everything, but we haven't really gotten there yet, Chris.
Okay.
I would add that our legislature was the first legislature in the country to ban the use of facial recognition by state government, after our governor did the same thing by an executive order. So, not to, obviously I can't speak for them, but it does seem as though they have a kind of, what's good for the goose is good for the gander sort of attitude towards privacy.
So just a matter of housekeeping, we have our next get together at the Pavilion in Montpelier. And the third one, I said it would be somewhere in White River Junction. Well, we're trying to secure the Department of Health facility that's in White River Junction. For those of you who want to visit lovely White River, that's probably where it will be, but we just are for some reason having trouble securing that conference room. It's the same place we had it a couple of years ago. So FYI, likely that's where it's going to be, but we just need to line up the conference room, and then we'll have clarity on the time. TJ asked me to make sure it was in the afternoon, so that's what I'm aiming for. Any other parting words anyone want to mention? Always feel free to email me. You probably have my cell phone, but I'll write it in the chat so that you have it there too. You can always call me if you want to talk through anything. I'm happily available. Nothing else. I would say we're done for the day, and just thank everybody for participating, for speaking up, for listening and thinking things through. It really helps Ryan and I in our work. And I think it's going to make for a really, you know, a good bill for Vermont when the time comes in January. So. All right, friends. Hopefully we'll see you at the end of the month when we meet again.
Thank you.
Thank you.
Take care, everyone.
Thank you.
Thanks, Charity.
Thank
Thank
you.
you.
Thank you, guys.
Thank you for actually coming out.
Yeah.